Good afternoon and welcome to the 2026 Trust, Probate, and Conservatorship Annual Litigation Update. My name is Teal Schoonover. I'm a co-chair of the Beverly Hills Bar Association's Trust and Estates Law section. Before we begin, I'd like to take a moment to introduce Nancy and Brian of the Sanborn team. Nancy and Brian have been the official sponsor since 2006. Nancy and Brian, feel free to say hello.
Thank you, Teal. In today's market, there's so many moving parts in a transaction between balcony inspections, surprise oak trees on a property, HOA issues, liens, judgments, and title problems. Unexpected issues can come up all the time. Most issues start when reviewing a preliminary title report, which is why Nancy and I spend a tremendous amount of time in the pre-listing phase trying to identify concerns.
So I kind of feel like we're a broken record, but most of these situations can be worked through when handled properly, but uncovering them up front avoids surprises during escrow, keeps transactions moving smoothly, and protects our clients throughout the process. If you ever need a preliminary title report for an upcoming sale, please reach out to us. Don't forget, California Title is a sponsor of this section, and we're always happy to help. Have a great meeting. I know this is one of the most popular meetings of the year.
Thanks, Nancy and Brian. In addition to the Sanborn team, the Trust and Estate section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, and Pickford Escrow Company. Now I'd like to turn things over to Jordan Parr to introduce our speakers. Thanks.
Thanks, Teal. I am delighted to introduce our speakers, Scott Rahn and Nicholas Van Brunt. Scott Rahn is the founding partner of RMO LLP, a probate litigation boutique based in Los Angeles, where he focuses exclusively on trust, estate, and conservatorship disputes. With more than 20 years of experience, Scott has represented clients ranging from individual beneficiaries and fiduciaries to global financial institutions. Before founding RMO in 2015, he held key litigation roles at national firms, developing deep expertise in fiduciary litigation and related regulatory matters. Nicholas Van Brunt is a partner in the Business Trial Practice Group and is the team leader of Shepherd Mullen's Private Wealth Services team. Nicholas focuses his practice on resolving disputes over trusts, estates, conservatorships, and other fiduciary matters. A respected member of the Los Angeles legal community, Nicholas is known as a pragmatic and effective trust and estates litigator who seeks to achieve favorable results for his clients through skillful negotiation, strategic counsel, and deft trial work. And now, let's get started.
Good afternoon. It's great to be back with you. Thanks, Jordan. Scott, good to see you again. Good back on the road with you. We've got a bunch of cases to go through as always. We're going to just jump right in. If you put questions in the chat, we'll be checking, but maybe if we have time at the end, which we've never had in 10 years, but maybe we'll this time, maybe we can answer some questions then. So I'm going to start off with Estate of Layla Boyajian, which is a case from July of last year in the 4th Appellate District, came out of Orange County. And it's a nice exposition on the meaning of the word canceled in the probate code, and we'll get to that. So Layla and Mike were married for 50 years, and they had 4 children, 2 of whom were Robert and Anush. In 2004, after those 50 years of marriage, Mike and Layla began divorce proceedings, and Layla perceived that her son Robert was taking Mike's side. So in 2006, when she was 71 years old, Layla signs a 2-page holographic will that leaves everything to Anush, who was living with Layla at the time. Fast forward 12 years later, appears Layla and her son reconcile on some level because she signs a document that's prepared by Robert that purports to revoke all of her estate planning documents, including all powers of attorney, advanced healthcare directives, wills, trusts, and authorizations of release from medical information. Layla dies, and Anush seeks to probate the attested will from 2006. Robert contests, claiming that the will was canceled by the 2018 document that he procured. In a detailed statement of decision, the trial court finds that Layla died intestate because the 2018 typewritten document had validly revoked the 2006 will, and that there was clear and convincing evidence that Layla intended to revoke her will. And importantly, the court found that the 2018 document, quote, constituted a cancellation under Probate Code Section 6120B, even if no physical act was inflicted or applied on the will. So Probate Code Section 6120B, as I'm sure you've all committed to memory, says that a will or any part thereof is revoked by being burned, torn, canceled, obliterated, or destroyed with the intent and for the purpose of revoking it. So the words burned, torn, obliterated, and destroyed all have a physical connotation. Canceled maybe seems like one of these things are not like the other, but then enter the Court of Appeal. The Court of Appeal, based on Anoush's argument, where Anoush contended that the trial court erred because revocation by cancellation must occur by physical alteration, agreed that the word cancellation is meant to go back to its meaning from the Gilded Age, which is that in its primal significance, to cancel a will required a lattice work or a crisscross drawn on pre-existing text. That's what it meant to cancel back in the old days. And so that's what the California Supreme Court happened to find in 1898 when last interpreting the statute. I don't know if it's the last case that interpreted it, but certainly on the statute. So when read in context with the other words, canceled is like burned, torn, obliterated, or destroyed. The court did concede that requiring physical alteration in 2025, or when this case was decided, is an ancient concept, perhaps in need of revisiting. Interestingly, the court also found that the typewritten document was not a subsequent will for three reasons. It was not a testamentary instrument because it was neither an instrument nor testamentary. It didn't name a beneficiary or transfer property. It just said that everything else was revoked. So just saying that it was revoked does not make it itself a will. It was also not witnessed by two people and therefore could not be a attested will. And Robert had cited no case or practice guide supporting his position. But anyway, long story short, at least as of right now, unless the legislature does something, canceled means physical alteration.
X marks the cancellation.
There you go. That would have been better.
Until the legislature decides otherwise.
Right.
Pleasure to be here with you again, Nick. Can't believe we've been doing this for 10 plus years. Crazy, time flies. Jumping into my first case, it is Powers versus McDonough. Stands for the proposition that the intended beneficiaries of a charitable trust have special interest standing to sue for enforcement of their benefits under the charitable trust. Sounds simple, it's not. In Powers, a group of disabled homeless veterans filed a putative class action against the Department of Veteran Affairs, the Department of Housing and Urban Development, alleging that the VA, which sits right out here from our offices here in Brentwood, failed to provide sufficient supportive housing on or near the West LA campus, which impaired their meaningful access to VA services, which placed them at risk of institutionalization in violation of the Rehabilitation Act. If you're a government lawyer, you may understand what I just said. Most of us probate practitioners, probably not. The veterans also claim that the VA's practice of counting disability benefits as income for purposes of determining area median income also prevented the most severely disabled of them from obtaining any VA benefits, housing benefits at all. The veterans went on to allege that the VA also had misused the land, that it had been deeded in the 1880s, again going back into the previous century, for the specific purpose of providing housing for disabled veterans. They argued that that 1880s deed created a charitable trust and that the VA had breached its fiduciary duty to them as the intended beneficiaries by failing to prioritize housing and services for them, and instead leased portions of the property to third parties, including a university, which shall remain unnamed, a private school that shall remain unnamed, and an oil company. Some of you, I'm guessing, have an understanding of who those entities are. The veterans also asserted that the third-party leases violated the Administrative Procedures Act and the West LA Leasing Act. The government, in response, moved to dismiss the veterans' claims, which efforts the district court denied, certifying the class and granting summary judgment on the benefits as income allocation issue, and the remaining claims proceeded to trial. After a bench trial, the court ruled in favor of the veterans, voiding the leases and issuing broad injunctive relief that required the VA to expand supportive housing and limiting its ability to renegotiate the leases to that university, private school, and oil company or otherwise. The government and the affected lessees appealed, and the issues on appeal as it relates to our practice here is whether the veterans as intended beneficiaries of that alleged charitable trust had special interest standing to sue to enforce to protect their benefits under that alleged trust. And then secondarily, whether the 1888 deed and subsequent federal legislation created a judicially enforceable charitable trust imposing those fiduciary duties. So the Ninth Circuit on appeal affirmed the district court's ruling that the veterans had special interest standing to pursue enforcement of their rights under an alleged charitable trust. The court applied a traditional balancing test, saying charitable trusts are generally enforced by the Attorney General to protect trust beneficiaries from excessive litigation by broad or indefinite beneficiary classes. However, courts can allow suits by beneficiaries with sufficiently direct and concrete interests. And here, the class of beneficiaries was narrowly defined: disabled, homeless veterans for whom the trust property was specifically intended to benefit. The benefits at issue similarly were concrete and life-altering for many, rather than some sort of abstract benefit that you couldn't really put your finger on. The court also noted the absence of meaningful enforcement by the Attorney General, who had done nothing to advance their interests, which it weighed in favor of allowing the veterans to seek private enforcement of their rights. All that is good and well until the Ninth Circuit, in the other part of their decision, reversed the district court's ruling on the charitable trust claim at all, holding that even if the 1888 deed reflected charitable trust principles, Congress had not clearly imposed judicially enforceable fiduciary duties upon the government. And absent an express statutory imposition of trust principles, trustee obligations, the VA's duties under the Leasing Act at all were statutory, not trust-based, and did not support a charitable trust cause of action. The charitable trust judgment was reversed on those grounds. So you win some, you lose some. You won the battle, but you lost the war, not to be too punny.
It's always fun when we can get a little bit of constitutional, statutory, federal analysis. We don't normally get to do that kind of stuff here, so that's
Sure.
not a fun outcome for certain people. Or
Certainly not.
Yeah. All right. So conservatorship of Ann S. It's funny. My kids are almost grown now, but my oldest son, when he was little, used to watch a show called Yo Gabba Gabba, and there was one song in that show that was "Don't Bite Your Friends." The moral of this is don't conserve your friends. Okay. Or maybe friends in quotes. So an attorney petitioned for the appointment of another attorney as probate conservator of the person in a estate of somebody named Anne. Who was Anne? Well, Anne was the petitioning attorney's neighbor who lived one street to the east. And he met Anne while he and his wife were taking a walk, and they chatted with her for several minutes during that walk. And meanwhile, the proposed conservator, who was not the neighbor, claimed he had known Anne and her late husband since 1990 and was a constant confidant and advisor to Anne. The petition was joined by a woman who had been Anne's healthcare agent since 2007 and was also supported by declarations from a family, friends, medical personnel, and other individuals claiming that she was being unduly influenced and possibly mistreated by her housemate. This, so far, doesn't sound so bad, right? Except for it's interesting that they only met once, but there's a lot of people that care about her. Okay. Anne objects to the conservatorship. Soon thereafter, the healthcare agent requests her joinder be dismissed without prejudice. That's a little curious. We go on. Anne's stepson then files a competing petition, and soon thereafter, the healthcare agent, the stepson, and Anne sign a settlement agreement to resolve the disputes in a way that they believe protected her from further financial abuse. Shortly thereafter, the proposed conservator substitutes out his attorney, and proceeds pro se to request dismissal of his portion of the joint petition. Problem solved. It's great. We figured out everything for Anne, except the attorney who originally filed the petition, again, not the petitioner, okay, not the proposed conservator, maintains the petition in his own right and also seeks that he get authorization from the court to get Anne to submit to a capacity declaration, which Judge Cadogan denies. The stepson, meanwhile, moves to approve the settlement agreement, and again, the attorney, the neighbor, opposes it. Anne then moves for sanctions against the attorney, arguing that he was a stranger with no legal authority to bring a petition or to participate in conservatorship matters concerning her, and seeks, some fees associated with that. Anne also moves for judgment on the pleadings based on the attorney's lack of standing under Probate Code Section 1820. The court then grants the motion and the sanctions request by Anne. The attorney appeals, the Court of Appeal affirms. And in its affirmation, there's a pretty good discussion of Section 1820, which discusses standing, which is a very broad concept, okay? But that, the proposed conservatee, spouse, domestic partner, relative, or other interested agency, person, or friend has standing to file a petition for a probate conservatorship. The attorney tried to suggest that he fit within this in three different ways, either as an interested person for the purposes of Probate Code Section 48, as a friend, or just as any person. None of these theories were availing. With respect to interested person, he was not someone who could be financially affected by the probate proceedings. And while the court has some discretion to allow someone to proceed as an interested party, there was no abuse of discretion here in doing so in light of what the Court of Appeal called the attorney's fleeting and tangential association with Anne. Second, the attorney was also not a friend. He met her once while walking in the neighborhood and did not dispute that Anne did not consider him a friend, so there was no error in concluding that he was no friend to Anne. And then third, the Court of Appeal concluded that the legislature did not intend to confer standing on anybody in the world to seek a conservatorship over someone else. Finally, the trial court appropriately found that the petition was legally frivolous after his attorney friend had withdrawn, as his argument lacked merit and provided no colorable legal or factual argument supporting an extension of existing law, even after he had been given the safe harbor period by Anne's counsel before the motion was filed. So again, maybe sometimes you do try to conserve your friend if it's necessary, but you really shouldn't try to conserve your neighbors, absent a good reason. Oh, and then I'm still up. Okay, Governor. Governor is probably going to come off our docket soon. Some of you are probably aware of this case already, but basically, Governor concretizes something I think many of us already understood under the law, which is that a demur may be filed at any time at or before the initial hearing date in a probate case. To give some background, Tom McDonald files a petition under the probate code to contest amendments to the trust. He seeks to specifically invalidate it, compel the trustee to provide an accounting, and to remove and replace the trustee. That same day, McDonald notifies Governor of the hearing to determine his claim to the property. 2 days prior to the hearing, Governor files a demur seeking to dismiss the claim. The trial court overruled the demur as untimely under CCP 430.40, which requires filing a demur within 30 days after service. Governor takes a writ, arguing that that Probate Code Section 1043 allows objections or responses at or before the probate hearing. So you got a conflict here. You got the civil procedure for demurs, and then you've got the probate code. So the key issue, of course, on appeal is whether the Probate Code Section 1043 or CCP 430.40 applies to demurs and probate litigation. And the Court of Appeal held that probate code controls and issued the writ of mandate. So 1043, again, says that an objection can be filed in writing in or before the hearing. While Probate Code Section 1000 does state that the CCP procedures apply under the probate code, it says they apply except when the probate code provides applicable rules, which Probate Code Section 1043 was. And a demur is a type of objection, so therefore it fits within 1043, end of story. There are a couple of other interesting notes just to think about. One of the arguments that McDonald made was that this was a contest. and therefore PC 8251, which prescribes a different procedure for the timing of filing a response, should apply. But McDonald had failed to grapple with Section 1040, which provides that Division 3, Part 3 applies except where the statute provides a different procedure, and 8251 doesn't apply to trust contests. It applies to will contests. So that argument went out the window. He also argued that it was absurd to allow an interested party to file a demur at any time before a hearing, and that means that this would apply to summary judgments as well. But there's no procedure in the probate code concerning summary judgment motions at all. So therefore, in that instance, according to the Court of Appeal, the CCP would apply. Finally, he argued that this interpretation would undermine the meet and confer requirement for demurs under the CCP. And the Court of Appeal ruled that, well, what that means is that 5 days before the probate hearing date, you should meet and confer. In other words, in civil litigation, you're supposed to answer a complaint within 30 days. You're supposed to meet and confer about a demur until, up to 5 days before that answer date. Otherwise, you get an extension. One thing the Court of Appeal did not decide in that case is whether the automatic 30-day extension of time that would apply in those circumstances applies where the parties are unable to meet and confer. So that question is left open. My guess is you could file the extension.
That would be my guess as well. Certainly seems that equity would dictate that result. But
well, especially because like normally you object, you can object at the hearing, and even if you just orally object, the court's invariably going to give you time, almost always, to file an objection. So it would be consistent with that, I think.
Yeah. It's important, the interplay between the various codes, right? And we run into these issues seemingly every year. And they are traps for the weary. If this isn't your practice area, certainly, as you mentioned earlier, commit these things to memory, but practice them dutifully. Moving on to the estate of Daniel Bodman. The estate of Bodman stands for the proposition that a nominated executor can be denied appointment based on pre-appointment misconduct under Probate Code sections 8402 and 8502. In Bodman, Dan passed away in 2016, and he left behind a large family and an insurance company that had created his family wealth. He had built and grown that insurance company with his wife, Heather, over more than 30 years. Dan, being a stellar member of the private wealth community, as many do, left a holographic will that named all 7 of his children, both biological and step, as co-executors of his estate, and directed that his daughter, Andrea, maintain the business, since she was the only one who had worked in it other than he and his wife, Heather. Andrea, unfortunately, was so riddled with grief that she was unable to act. So she dutifully anointed her stepbrother, Thomas, to take an active role in managing the business, because Thomas was a business person. He had an MBA and had recently had a large liquidity event, so he also had time in addition to just wherewithal. When Thomas came in, conflict quickly arose between him and Heather, who, as I said, had been growing the business with Dan for more than 30 years. Tom came in like a bull in a china shop and was aggressive with her, directing her how to run the business, directing her how to manage client relations that she had managed with Dan for decades, telling her how to communicate with people via email, and directing her on how to provide him information so that he could manage the business as he helped her step aside. Due to Thomas's hostilities, specifically with regard to Heather, the business, which was the primary estate asset that had generated hundreds of thousands of dollars in income every year, suffered, and the revenue and profits drastically declined over a relatively short period of time. To secure his position of control and influence, Thomas then sought appointment to act as executor, as one of the 7 nominated children. And after a lengthy bench trial, the court disqualified Thomas from acting due to his, quote, unwarranted, aggressive, and disrespectful treatment of Heather and the damage that that treatment had caused the business. The trial court concluded that Thomas's behavior and the impact of that behavior constituted mismanagement of an estate asset, and that disqualified him from acting. Thomas, undeterred, appealed. And the question on appeal was whether the probate court can deny appointment of a nominated executor if he's disqualified under 8502. Whether mismanagement of the estate under 8502A applies to conduct that occurred before they were ever even appointed as an executor, and whether his aggressive and disruptive conduct, that material harmed the estate asset, really constituted mismanagement of an estate asset, again, under 8502. And perhaps not shockingly, the Court of Appeal affirmed, holding that a nominated fiduciary can be denied appointment where the court determines they would be subject to removal for the same mismanagement that is at issue in determining their appointment. The court held that mismanagement is not limited to fraud or intentional misconduct and can include pre-appointment conduct. The appellate court affirmed that there was substantial evidence supporting the trial court's finding that Thomas's hostilities had harmed the business, and that alone justified his disqualification.
On that, just real quick on that, it is interesting that, I mean, that does feel like an argument you get a lot, that pre-appointment conduct shouldn't factor into the decision. I do wonder how the statute of limitations would play into that. I don't think the court decided that, but it's an interesting.
Well, and I think the other side of that coin, Nick, is the hostilities issue, right? I mean, often there are hostilities, right? If there weren't hostilities, Nick and I'd have nothing to do, and we wouldn't have any cases to talk about. Thankfully, there
Don't
is.
air our personal laundry, Scott.
That is an aside. But you know, the hostilities have to elevate to such a level that it really interferes with the administration, right? And I think that's a very, that's a needle that you have to thread in these cases, right? Is there hostility? Sure. Right. But is it really interfering with the administration of the estate? And is it causing harm to the estate, the assets, the beneficial interests? So I think that's just an important, factual scenario here that you can look at to see, what Thomas was doing. It could have been a closer call than perhaps it was. Right. The next case that I'm going to run through is Doe versus Kakru. And it deals with pleading elder abuse. This again is another case that perhaps we wouldn't normally cover, but it does deal with the issue of how to plead an Elder Independent Adult Civil Protection Act claim, which requires that the recklessness, oppression, fraud, or malice be pled adequately. So here, Jane Doe sued her obstetrician and others who were involved in the delivery of her child. She alleged that she had expressly refused both a C-section and a vacuum-assisted delivery, but the physician proceeded with the latter over her objection. She asserted multiple causes of action, including medical battery, gender violence, abuse of a dependent adult under the Welfare and Institutions Code. And the allegations, to be kind, the allegations regarding the Welfare and Institutions Code claim were sparse, essentially just regurgitating the statute. And the obstetrician demurred, and the trial court sustained the demur without leave to amend. Jane Doe appealed, and the question was whether the boilerplate allegations satisfied the pleading standards for the Elder Independent Adult Civil Protection Act and Welfare Institutions Code claims. The appellate court said no. They did retain the claim or reverse on the demur for the medical battery claim, but the court said that the Elder Independent abuse claims did not provide enough specificity, right? You have to plead with specificity how the acts were reckless, oppressive, fraudulent, or malicious, and she didn't plead anything. She just regurgitated the statute and failed to meet her pleading standard.
So, yeah, we say that it's a notice pleading state, but you still gotta tell something of a story.
You got to at least try.
Yeah, exactly. All right, the next case is Gamo versus Morel. This is an interesting analysis of the attorney fee shifting statutes that are out there when it comes to financial elder abuse claims. So Gamo purchases a Maserati from J-Star and somebody named Jared. And he claims that the sellers had orally misrepresented to him that they would credit him $6,500 for his trade-in value on his car, but he was only credited $2,000. So $4,500 dispute. Keep that number in mind. Gamo later sues them for financial elder abuse, violation of the Consumer Legal Remedies Act, that's CLRA, and other related claims. During discovery, the defendants serve a powerful tool, request for admission, and they ask Gamo to admit the following 5 things. First, that he had initialed each page of the contract. Second, that he was given time to read the contract. Third, that the seller went over the part of the contract with him showing it was valued at $2,000. 4, that he did not have any condition that would have prevented him from reading or understanding the contract. And 5, that the seller had not altered the terms of the contract. Gamo denied, and where he had admitted, withdrew his admissions on the request for admission. Well, the sellers then prevail on all claims at trial. And the seller then filed fee motions for $490,000. Again, the amount of dispute was $4,500. The $490,000 fee claim was based on 2 theories. First, a cost of proof sanctions motion under Code of Civil Procedure 2033.420. And what that does is it allows a party to request fees where requests for admissions are served and the responding party unreasonably fails to admit a request that the serving party later proves true. And then the second theory was a motion for fees under the CLRA, which has a prevailing party provision when something's prosecuted in bad faith. The trial court held that the fee request was actually barred under the Welfare and Institutions Code, which awards fees to prevailing plaintiffs on financial elder abuse claims, but not prevailing defendants. And because the fee shifting was unilateral, it actually barred the defendants from obtaining their $490,000 in attorney's fees, where the claims were in the nature of financial elder abuse. A lot at stake, the sellers appeal. And they argue on the appeal that both the cost of proof sanctions and the CLRA fees were independently proper bases for awarding fees, separate and apart from the Welfare and Institutions Code. And the Court of Appeal agreed and reversed, at least as to the cost of proof sanctions. Because even though the Welfare and Institutions Code elder abuse fee shifting is unilateral, the cost of proof fees were appropriate where Gamo had failed to admit certain RFAs without good reason. And that caused the sellers to have to incur a lot of fees, apparently, to prove the truth of their requests. And the purpose that statute serves is different, right, than the statute for prevailing party fees in an elder abuse case. And those statutes can apply concurrently. Even though the court found that way in the cost of proof sanctions, it didn't find that way in the CLRA because the CLRA fees, like the financial elder abuse statute, was really a prevailing party provision. So there wasn't necessarily a distinction between the two. In fairness, the sellers didn't actually really argue that issue all that effectively on appeal, so I'm not sure that issue was really decided in a firmly precedential way, one way or the other. The more important point is understanding that, unlike prevailing party fees, cost of party fees do, quote, not punish a litigant merely for pursuing a claim. The litigant must instead reimburse an opposing party's costs in proving an issue where the litigant did not have a reasonable good faith belief it would prevail at trial on that issue after being expressly requested to admit the issue. So this can be a pretty powerful device in litigation. It's something to think about early on in a case when you're serving your request for admission. It can create some leverage for settlement. It's not a bad approach, and I thought this decision did a really nice explanation. In the Court of Appeal did a nice explanation of why they can be useful.
Yeah, I mean, it's an important tool on both sides, right? You have to obviously pay attention in preparing them and pay attention in preparing the responses.
Absolutely.
Because of the potential exposure can create, settlement leverage. And it's something that you need to be monitoring throughout your case, right? Cases vacillate, they get better, they get worse. New facts are discovered, revealed, etc. So paying attention to this part of the process obviously is important. The next case I'm going to cover is Rahn versus Pagano, deals with the recoverability of fees when there are competing elder abuse claims, and stands specifically for the proposition that the unilateral fee recovery provision in the Welfare and Institutions Code does not preclude a petitioner who is also a respondent defending against a counter financial elder abuse claim from recovering fees and costs incurred in the prosecution and defense of those claims, as long as the prosecution and defense are sufficiently intertwined so as to make separating fees impractical for the court. So in Pagano, Kelly and Michael Pagano cared for 83-year-old Charles after he was discharged from the hospital following a serious illness. Under their care, they were kind enough to take Charles to an estate planning attorney to have prepared for them, a new trust that significantly benefited them. Once the new trust was in place, the following week, in fact, the Paganos determined that, hey, we're no longer able to provide care for Charles, and dumped him or moved him into hospice care. Charles's nephews discovered him there, and the next month had him execute a new trust that substantially benefited them and disinherited the Paganos. Shocked and appalled, the Paganos filed suit. They filed a civil action and a probate petition, alleging that Rahn and his fellow nephew had committed, or his cousin rather, had committed financial elder abuse by unduly influencing Charles to execute the trust that benefited the Rahns instead of the Paganos. Rahn, as trustee of the new trust, filed a competing probate petition, alleging that it was in fact the Paganos who had committed financial elder abuse in obtaining their trust. After an 8-day trial, the probate court found that the Paganos indeed had unduly influenced the creation of the trust benefiting them, which supported a finding of financial elder abuse. And the court also dismissed their competing claim for elder abuse against Rahn. The court awarded Rahn compensatory damages under 859, including over $500,000 in attorney's fees. Seems to be a theme around that number. And the Paganos, because it's real money, appealed. And the issues on appeal were whether the Welfare and Institutions Code section on unilateral fee shifting precluded an award of attorney's fees to Rahn because he was also defending against the Paganos' unsuccessful competing elder abuse claim. Another issue was whether the Carver versus Chevron and related cases barring recovery of overlapping fees where claims subject to unilateral fee shifting provisions are intertwined with other claims applied. And finally, whether the probate court had abused its discretion in awarding all of the requested fees without apportioning them between the prosecution and defense of those claims. And on appeal, the Court of Appeal affirmed, holding that Carver and its progeny were distinguishable because they involved prevailing defendants seeking fees under either bilateral, contractual, or statutory provisions that directly conflicted with the unilateral fee shifting statutes that were designed specifically to encourage plaintiffs to bring these kinds of claims. Here, Rahn was not only a prevailing defendant seeking reciprocal fees, he was the successful petitioner on his own petition, asserting a financial elder abuse claim, which is the exact type of claim Welfare and Institutions Code 15657.5 was enacted to encourage. The court also concluded that awarding fees to Hahn did not undermine legislative intent because his prosecution of that claim was substantially intertwined with his defense. The court found that because Hahn's fees all related to litigation centered on financial elder abuse, apportionment was impracticable. And while fees attributable exclusively to his defense of the Pagano's petition would be subject to exclusion, the record supported the probate court's determination that the prosecution and defense work was fully intertwined and could not be apportioned reasonably.
All right. Starting to see more and more of these attorney fee cases under the Welfare and Institutions Code making it up. So more to come on that, I'm sure.
Yep.
Another interesting case is Halperin versus Halperin, which is the latest in the series of intentional infliction. No, I have to do that every time. Intentional interference with expected inheritance claims, IIEI, which was made part of the law here in California under the Beckwith case, within the last 15 years. Anyway, so to state an IIEI claim, there's 5 elements you got to meet. A plaintiff has to have an expectancy of an inheritance. There needs to be causation, i.e. facts demonstrating with reasonable certainty that the plaintiff would have received a bequest or devise if not for interference by the defendant. 3, there has to be intent, i.e. that the defendant knowingly and deliberately interfered with the expected inheritance. 4, that the defendant's deliberate conduct was independently wrongful for a reason other than that it just that the defendant interfered with the inheritance. Usually that could be fraud, undue influence, etc. 5, resulting damage. So those are the 5 elements. And again, the IIEI defendant must also direct the independently tortious conduct of someone other than the plaintiff. Usually that's going to be the testator, or intestate person. IIEI cannot be pursued, and that's where this case comes from, if there's an adequate probate remedy that exists. So in Halperin, Warren establishes a trust in 2014, and he has 3 children, Susan, David, and Michael, who he makes their beneficiaries. On January 1st of 2021, Susan learns that the trust was more favorable to David and Michael than her because they received their shares outright and free of trust, while she received IRA retirement accounts and alleged the fair market value of her gift was about $1 million less than her brother's. Not a very happy new year for Susan. In December 22, while Warren is still alive, Susan alleges in a probate petition, should have had that off. Susan alleged in a probate petition that David and Michael had isolated their father and sought to remove David from various fiduciary roles. Shortly thereafter, Warren dies, and for reasons that perhaps Susan and her lawyers only know, Susan then dismisses her petition on May 1st. Fast forward 10 months later, on March 2024, Susan files a complaint for intentional interference with expected inheritance and intentional infliction of emotional distress, making this even more difficult for me to tell you about. Anyway, she dismisses the IIED claim and adds a claim for elder abuse. David Demers is arguing, among other things, that Susan had no standing because Susan had an adequate remedy in probate. And the trial court agreed and sustained the Demers without leave. Susan appealed and the Court of Appeal affirms. Susan was Warren's child. She was a beneficiary. She therefore had standing, for example, to contest the trust or to seek to reform the trust. She also she argued, nevertheless, that though she had standing in probate, the trial court should have allowed her civil tort claim because any remedies that she could receive in probate would not be adequate. But Susan did not identify what the potential remedies or procedural avenues were in probate nor explain why they were inadequate or inappropriate. Instead, she asserts broadly that she could not obtain adequate relief because no amendment to Warren's trust was executed, so, quote, there was no instrument to contest, construe, or set aside, and probate cannot award tort damages against individual actors. But Susan could have sought modifications or other relief under Probate Code Section 17200 to argue that Warren had intended to make such a revision, as she essentially did in the probate petition that she had filed and then dismissed. Now, Susan relies on a case called Gomez versus Smith, which did have some similarities to the present case. And in Gomez, a wife sued her husband's children from a prior marriage for IEI, where they prevented husband's attorneys from having husband sign new documents that would have favored the wife. And it's true that the wife may have indeed had an adequate remedy in probate, but no one raised the issue on appeal. So just because the case is similar, so what? Susan also argued that the trial court should have transferred the case to probate. But again, the issue here wasn't which department should handle the case, but rather whether she had an adequate remedy. Personally, I think the decision's a little curious. I'm not sure that Susan really did have an adequate remedy in probate. I mean, again, maybe she would have had standing under barefoot. I mean, she had standing under barefoot for sure. And she probably could have filed a petition under 17200. I don't know if she could have gotten everything she wanted. I'm not sure why she couldn't have joined other tort claims if she wanted to. But it does, for those of us, and I think there's probably a lot of us here who have IEI cases, this is an important decision to read.
Yeah, along with Gomez. I mean, and the facts and circumstances are so different between these two cases as well, right? I mean, in Gomez, you had the deceased husband's kids literally chasing away the estate planning attorney, right? Like chasing him back into his car and watching him, burn out to protect himself from perhaps being beaten. So, facts dictate some of these outcomes as well.
Right. I wouldn't say it's not necessarily bad facts make bad law. It's just facts make law, a lot of the time. So I think very different cases.
Another 859 damages case, and it deals specifically with the defendant's ability to pay and whether that's something to be considered when awarding 859 damages. This is Maura Marco versus Ed Nowakowski, where the court held that the double damages penalty for a bad faith taking of trust property under 859 is mandatory. And once that finding has been made, trial courts do not have the authority to reduce the penalty based on ability to pay or otherwise. In Maura Marco, Ed was an attorney and he was serving as a successor trustee. And in those capacities, he misappropriated nearly $400,000 from a trust through admittedly unauthorized electronic transfers. After he was disbarred and after he pled guilty to criminal grand theft and embezzlement charges, the beneficiaries of that trust sought double damages under Section 859. Ed admitted he took the money, but argued that the court should reduce the double damages penalty due to his deteriorating health and insolvency, claiming that the only thing he really had left was his family home. And the probate court rightfully rejected his argument, finding that his misconduct as a fiduciary was particularly egregious, stealing the money, admitting that he had stolen it. And the court said the penalty was intended to deter exactly the type of betrayal that he had perpetrated against this trust. And Ed appealed. And the issue on the appeal was whether the court has legal authority to consider someone's ability to pay as a mitigating factor when imposing mandatory double damages penalties under 859, and whether the mandatory double damages penalty violated some federal or state constitutional protections against excessive fines. Ed was pulling out all the tricks here. And whether a court can reallocate a restitution payment to satisfy accrued prejudgment interest before applying the remainder to the principal balance. Again, trying to minimize this as much as he could. At the end of the day, the Court of Appeal affirmed the judgment, ruling that Probate Code Section 859 imposes a mandatory penalty that leaves no room for judicial discretion regarding a defendant's financial status. The court concluded that the penalty did not violate constitutional protections because it is not limitless, but is tied directly to the value of the property that was taken in bad faith. While awarding the award of attorney's fees and interest, the court did direct the probate court to amend the judgment to ensure post-judgment interest did not accrue on the pre-judgment interest amount, but otherwise Ed was left with the bag he had brought for himself. Moving into the last 10 minutes, not quite a lightning round, but near it.
Before we do that, just real quick,
Yeah,
just
go
an
ahead.
interesting thing on, because this is the first time we talked about that case.
Yeah.
It's just interesting. I mean, you have punitive damages awards, and that is a different analysis, right?
Mhm.
For punitive damages, you actually do look at, generally speaking, the ability to pay the defendant. That's one of the
Yeah, great point.
So it shows that, I mean, 859 is, in some ways, could be more of a friend, because a lot of times you'll see pleadings that seek both, right? But 859 might be your, and the standard's not necessarily any harder than for punitive damages either, right? I mean, you have to show bad faith in the appropriation. So yeah, it's powerful.
Yeah. Yeah, to a certain degree, I think as you just described it, perhaps a slightly lower bar than punitives. And I think just the idea of it being a penalty versus it being punitive in the ask, right? And showing bad faith is all that is required. You get there, you show undue influence, and you're checking the box. So it is a very powerful tool, to wield and to defend against it as appropriate.
Now we have 9 minutes for the lightning round. Sorry.
Moving into LPS conservatorships, I've got one I'm going to talk about before Nick dives into his last couple of cases. This is the conservatorship of the person of AB. Stands for the proposition where the Court of Appeal affirmed renewal of an LPS conservatorship and involuntary medication order, holding that substantial evidence supported findings that the conservatee of the ward was gravely disabled and therefore lacked capacity to give or refuse informed consent to meds. The background here, the public guardian had petitioned to renew an LPS conservatorship and involuntary medication order for AB, a 42-year-old who had been diagnosed with schizophrenia disorder and had a long history of psychiatric hospitalizations, paranoia, delusions, and medication noncompliance. The evidence had showed that while AB was under conservatorship and medication orders were lifted, he repeatedly stopped taking medication, decompensated, and required hospitalization or emergency intervention. At trial, AB argued that he now understood his illness and the need for medication following a psychiatric episode in 2023, and therefore he was not presently gravely disabled or incompetent to refuse medication. The trial court really leaned into the testimony of AB's treating psychiatrist and his mom, and found AB gravely disabled despite his revelations, renewed the conservatorship, and reimposed the involuntary medication order and AB appeal. And the question on appeal was whether there was substantial evidence supporting the finding that he was presently gravely disabled under the LPS Act, whether a conservatorship can be renewed where the conservatee remains stable while medicated, but has a history of stopping meds when not subject to court orders, and whether substantial evidence supported the finding that he lacked capacity to give or refused consent to medications. And the Court of Appeal affirmed. I'm going to skip all of the explanations around it to give Nick time to go through his last couple of cases.
Thanks, Scott. So we've got 2 more LPS cases, and we recognize that not all of us do LPS work. I mean, a lot of times we don't. It's the county that's involved, right? Maybe some of us do defense. But some of these cases have important principles, and I think BK, conservatorship of the person of BK, which I'm about to talk about, does have those principles because it talks about the right to a jury trial in a conservatorship proceeding, and that does happen for probate conservatorship matters that some of us really do handle. So in conservatorship of the person of BK, BK is under an LPS conservatorship. LPS conservatorships need to be renewed each year. And in a hearing on renewal in October of 24, BK requests a jury trial. And then in January 2025, BK's counsel informs the court that BK actually wants a bench trial. So the court proceeds with the bench trial, finds that BK remains gravely disabled and renews the conservatorship. Interestingly, BK appeals, contending that the trial court had not done enough to advise BK of jury trial rights or to ensure that the waiver was knowing and intelligent. Now, to be clear, the record's as follows. In October 2024, BK said 4 times on the record that she wanted a jury trial. But then at the subsequent hearing on January 9th, 2025, BK is present with her attorney, so that's important, okay? And the court asked BK, do you know why we are here today? BK says, I want to terminate my conservatorship. The court says, well, there would be a trial. And then the following colloquy occurs. The court, so you have demanded a trial. I have not had a waiver as of yet. Counsel for BK. So we had a conversation about court versus jury trial, and that we would have the court trial today. And I believe BK would like to have her trial today, which would mean it would be a court trial for me. BK then says, yeah. And the court says, okay, so that means you are waiving and giving up your right to have a jury trial, to have a court trial today with me. Is that right? BK, right. The court, counsel joins. Counsel, yes. Long story short, the bench trial proceeds. It's pretty clear that BK was still suffering from schizophrenia and was gravely disabled. The court so found. Now, BK argued that she had a right to jury trial and that to waive that right, the court either needed to properly advise BK regarding the nature of that right and obtain a personal waiver, or allow counsel to waive the jury trial upon a finding of incapacity as a precursor to the trial itself. And BK contended the record did not show that her agreement to waive a jury trial was knowing and voluntary. Court of Appeal disagreed. BK acknowledged on appeal that she was aware she was entitled to a jury trial. She repeatedly requested it at the prior hearing. And her counsel then told the court in her presence that she was waiving a jury trial, and BK confirmed it on the record. And then the trial proceeded without objection. So the court was not required, this is the important part, the court was not required to make a specific on-the-record showing as to each right where counsel was present for a waiver to be voluntary and intelligent. And even if there was error, it was harmless, as BK didn't actually challenge the finding that she was gravely disabled. But, leave that where you like. Last case is conservatorship of AJ. I can go through this pretty quickly, but the takeaway from this case is that the trial court ultimately determines what the least restrictive placement is in an LPS conservatorship. In conservatorship of AJ, AJ is diagnosed with schizophrenia, found to be mentally incompetent to stand trial on assault and battery charges. The criminal court later vacates its incompetency order and instead directs the public guardian to investigate whether to file an LPS. The public guardian investigates, ultimately files, determines AJ is gravely disabled and unwilling to voluntarily accept treatment. After a jury trial, the AJ is found to be gravely disabled and appoints the PG as conservator, and delegates its power to place AJ in psychiatric nursing or other state licensed facilities to the public guardian. AJ appealed, arguing that this delegation was inappropriate and that the public guardian had improperly argued involuntary detention as evidence of AJ being unable to provide for his own shelter. So the key issues there is whether the jury improperly relied on AJ's prior involuntary hospitalizations to find him gravely disabled, but then whether the trial court erred by delegating the responsibility to designate the least restrictive alternative. The court affirmed the findings by the jury, but remanded to the trial court to determine the least restrictive placement for the conservatee, because it was the duty of the trial court to make that decision, not to delegate it to the public guardian. So, that's actually, it shows that the system does sometimes protect the rights of individuals in these cases. That this individual had the right to get a determination from the court, not the public guardian, who's of course trying to protect them, but not the public guardian to make that decision. We do have one Q&A that I'm not sure I totally understand. So it says, can we talk about conservatorship for a disabled child? So children are not conserved. Children are in guardianships. What we do have are limited conservatorships for people who have developmental disabilities that turn 18 and maybe continue to need help for 7 specific enumerated powers under the under the probate code. That could be a whole other hour of just, in fact, it has been a whole other hour of discussion before. So, but it's a good question.
I think that's the last question. I think we're at time. Thank you,
Oh.
Nick. Here's to the next 10 years.
Here's to the next 10 years. And Ashley, we'll be discussing that case next year. I guess that we'll make sure we get that right. All right. Thanks, everybody.
Thank you, Scott and Nick. And this concludes today's program.